We've just heard from International Relations Director General Zain Dangle about Israel's promise to fight against accusations of genocide by South Africa. Well, let's discuss this further with international law expert Professor Cathy Powell. He's been listening in. Professor Powell, I appreciate your time this evening. Now, what specific evidence does South Africa present in its 84-page suit to support the accusation of genocide by Israel in Gaza since October 7, 2023? And we do know that South Africa is the first nation to put in the suit.
Evening, Hugo. South Africa has put in evidence of genocidal acts and genocidal intent. Genocide is a specific crime, a particular crime, because it requires not only certain acts of killing, harming, or making living conditions impossible for a group, but it requires that these acts be accompanied by an intention to destroy in whole or in part a national, racial, ethnical, or religious group. That's how the Genocide Convention phrases it. So what South Africa has put into its application is evidence of the destruction or killing of Gazans, destruction of their living conditions, the possibility of surviving, withholding of food, water, and aid. And then it's added statements made by members of the Israeli government, Israeli officials, and Israeli army reservists that suggest genocidal intent. So either dehumanizing language about the Palestinians or statements such as wipe Gaza off the map, or in the case of the army reservist, if you have an Arab neighbor, go out and kill him now. So those comments, combined with the carnage in Gaza, are suggested as evidence that Israel is either committing genocide or failing to prevent it, which is one of its other obligations under the Genocide Convention.
Professor Powell, a couple of issues, and the first one, I suppose, stems from the fact that Israel was attacked by Hamas on October 7th, right?
Correct.
Now, they were obliged to defend themselves and defend their people. So at what point does genocide step in? Because the first port of call is if you're attacked, you will retaliate, and that's what they did, except that they've done this over a prolonged period.
Okay, you're actually bringing up three different areas of international law. One is the right of a state or a unit to use force at all. That's what you're relying on when you say Israel had a right to defend itself. The next area is how a state may use force, which will govern whether you may kill civilians and how many civilians, and the idea of disproportionate attacks and so on. And then the third area is genocide, which is actually a completely separate crime, often connected to armed conflict, but it actually is completely unrelated to either the right to use force or the rules on how you may use force. So this is not about whether Israel may defend itself. It's not about how Israel may defend itself. It's about whether Israel is trying to destroy a racial, national, ethnic, or religious group in whole or in part, or failing to prevent the destruction of a racial, national, ethnic, or religious group. So I think, yes, carry on.
So we're in agreement that Israel was obliged or had the right to defend itself, but it seems that the issue is the fact that a number of Israeli government officials then came out and said that they, for instance, wanted to wipe out all the people in Gaza. Had they not said this, hypothetically obviously, had they not said these statements, which seem to be a big part of the case of South Africa to ICJ, would the issues of genocide been a factor?
No. With genocide, you need genocidal intent or you don't have the crime. So that is why South Africa put so much information suggesting genocidal intent, all those statements, into its application. Had Israel merely responded disproportionately, which it has done, then we would be talking about war crimes. And that's not covered by the Genocide Convention, and there would be no reason, there would be no basis on which to take Israel to the ICJ. But because what it was doing was accompanied by statements suggesting genocidal intent, there we have a case for presentation to the ICJ.
So let's talk about the significance of South Africa's request for urgent action by the ICJ to prevent Israel from committing further crimes in Gaza. And what measures is South Africa specifically seeking?
It's seeking, I suppose, in the shortest possible description, a ceasefire. So it's seeking for Israel to stop attacking Gaza and to allow humanitarian aid into Gaza. It's seeking, in other words, for Israel to make it possible for Palestinians to survive. So this would involve not blowing up any more buildings or shooting any more people, and allowing medical and other relief to come in to assist the people who've been injured or who are starving. Because the other problem with the Israeli response to the attacks of October 7th is the complete blockade on food, water and electricity for the entire region, which makes living conditions impossible.
Now, what we do know about the powers of the ICJ is that they are limited to some degree. They cannot institute a mandatory stoppage or institute the ceasefire themselves, but they can make recommendations. Is that correct?
No, that is incorrect. The South Africa and Israel have both accepted the jurisdiction of the ICJ by signing the Genocide Convention, which includes a provision referring disputes under that convention to the ICJ. So both South Africa and Israel are subject to the jurisdiction of the ICJ and are bound by its orders in this matter. That might not force Israel to actually carry them out, as we saw when Ukraine won an order against Russia, and Russia just ignored it. So the enforcement powers of the ICJ are weak. In fact, the ICJ has to rely on the Security Council, which is not going to help very much here, because any measure that the Security Council tries to come up with will be vetoed by the USA. So I'm not saying that whatever the ICJ says will necessarily happen, but it is binding in law. And the fact that Israel does not comply with instructions issued by the court will have an effect later on in the case when the merits of the case are decided.
Professor, as an international law expert, what are your thoughts on the likelihood of success, firstly, of South Africa's application, and secondly, how likely are we to get a judgment, if we may call it that?
Well, there are two judgments that we're waiting for. One is the provisional measures judgment, and the other one is the judgment on the merits of the actual application. Provisional measures, I suppose, in domestic law terms, you call that an interdict. That's a request. The request for provisional measures is a request that the court issue an order that stops things from getting worse. And the provisional measure request specifically has been the ceasefire and allowing aiding. Now, I can't see that not being granted, because that is something that prevents irreparable prejudice in the meanwhile, while the court decides that it definitely has jurisdiction. All the court needs to grant provisional measures is prima facie jurisdiction, so a case, a credible case that it has jurisdiction. It needs the state that's bringing the application to actually have a right it can assert, which South Africa can do under the Genocide Convention. And then it needs the measures that South Africa is requesting to actually have some connection to the case that's being complained of, which is genocide. So that also fits. And then finally, there needs to be risk of irreparable prejudice if the court does not issue an order of provisional measures. And given how, we're looking at 22,000 dead Palestinians at this point, I think we've established irreparable prejudice if this carries on. So I think the likelihood that the court finds it has jurisdiction is very high. I think that's a no-brainer. The likelihood that it will issue provisional measures is also very high. Then the court has to go actually into the work of examining the law and the facts, and that's going to take a bit longer. On the evidence that South Africa has produced in its application, there is a strong case for both genocidal acts and genocidal intent. And just remember, the Genocide Convention also gives states an obligation to prevent genocide. So even if the court were not to find that Israel is actually committing genocide, it might find that Israel has failed to prevent it by failing to react when people that are not its officials make genocidal statements.
Professor Powell, appreciate your insights. Thank you kindly for speaking to us.